Welcome to another edition of CCK Live. My name is Alex Gamache, and today I'm joined by my colleagues Brandon Paiva and Dallas Aguar. In this video, we'll be discussing the top 5 mistakes veterans can make when filing claims for PTSD. So before we get into those mistakes, Dallas, do you want to start off by giving us an overview of what PTSD is and some of the symptoms that accompany it?
Yeah, thanks, Alex. So post-traumatic stress disorder is a mental health condition that occurs as a result of experiencing a distressing, shocking, or otherwise traumatic event. Many veterans develop PTSD from events they witnessed or experienced during their military service. Symptoms and severity of PTSD can vary from person to person. It really is different for everyone. But the most common symptoms include re-experiencing the trauma through intrusive or distressing recollections of the event, flashbacks, and nightmares, emotional numbness and avoidance of places, people, and activities that are reminders of the trauma, and increased arousal such as difficulty sleeping, concentrating, feeling jumpy, and being easily irritated and angered. VA rates PTSD under 38 CFR section 4.130 with an assigned diagnostic code 9411. PTSD, like other psychiatric conditions, is rated under the schedule of ratings for mental disorders and can be assigned anywhere from a non-compensable or 0% rating to 10, 30, 50, 70, or 100% rating.
Thanks, Dallas. Now that we have an overview of PTSD, we're now going to move into discussing the claim mistakes veterans run into when filing their claims. Brandon, did you want to kick us off with the first mistake?
Absolutely. Thanks, Alex. Oftentimes, filing a claim for VA benefits can be confusing, and many veterans make mistakes that can potentially delay their benefits or even result in a denial of their claim. In this video, we're going to go over 5 of the top mistakes veterans make when filing VA claims for PTSD and how can they be avoided. The first one we're going to touch on is failing to show proof of a stressor. To obtain direct service connection for PTSD, veterans must demonstrate an actual diagnosis of PTSD, an in-service stressor, and a nexus between the two. Generally speaking, the occurrence of the stressor should be consistent with the circumstances of the veteran's service. However, in some cases, veterans need to provide VA with evidence to corroborate the reported stressor. Failure to do so can result in denial of benefits. Corroborating evidence involves evidence from a source other than the veteran, supporting the claim that the in-service stressor had actually occurred. Such evidence can include things like buddy statements, military records, newspaper articles, police reports, and basically anything that aligns with the veteran's time in service and the reported stressor that he or she believes they suffer PTSD due to.
Okay, awesome. It's always good to have evidence that backs up your statement and corroborates your stressor. The next mistake we'll get into is not submitting all of the necessary forms. For initial claims, veterans should download and fill out VA Form 21-526-EASY when applying for benefits. This can be submitted via mail to the Claims Intake Center, in person at the closest regional office, or electronically through VA's website. The same applies if you previously filed for service connection for PTSD in the past and have been denied. If this is the case for you, you will need to file a VA Form 20-0995 or a supplemental claim form with new and relevant evidence. An example of new and relevant evidence that can be submitted is using VA Forms 21-0781 and 21-0781A, which are both forms to document the veteran's onset of their PTSD. So all in all, it's important to send the necessary claim forms to avoid any delays in the VA process. The third mistake we're going to discuss is thinking that you need to meet all of the VA rating criteria. Dallas, did you want to go ahead and discuss this topic?
Yeah. So this is another mistake that's really common. Since mental health conditions like post-traumatic stress disorder can manifest differently for everyone, VA's rating formula for mental health conditions isn't binding. You don't have to meet all the requirements. So the veteran doesn't need to exhibit every single symptom listed in the rating criteria to receive that particular disability evaluation. A Court of Appeals for Veterans Claimed case, Marham v. Principi, established that symptoms listed under the schedule of ratings for mental disorders found in 38 CFR section 4.130 are not intended to constitute an exhaustive list, but rather they serve as examples of the type and degree of symptoms or their effects that would justify a particular rating. So what this means is a veteran can have any number of the symptoms listed in the rating criteria and still meet that level of valuation.
Yeah, and I think that's great to point out too, because a lot of veterans will get discouraged if they don't meet every single criteria in that 4.130. So even if you are exhibiting symptoms within multiple different ratings, it's always good to continue to argue rating a higher rating if you do exhibit symptoms in that criteria for that rating. So moving away from claim forms and ratings, another mistake veterans fall into is relying solely on their C&P exams. Brandon, did you want to go over the VA process?
Absolutely. We all know that C&P exams or compensation and pension examinations are a necessary part of the claims process and are usually weighed pretty heavily by VA. But veterans should avoid relying solely on their exam results. C&P exams may not adequately represent the true nature or the extent of a veteran's condition, or even their mental health conditions can be more difficult to quantify since they affect everybody differently. Expert opinions and nexus letters may be helpful in this case, as they may provide a clearer picture of the veteran's symptoms or counter the VA examiner's findings. The veteran's physician or even a medical provider can provide a nexus letter to help with their claim. Accredited representatives or attorneys may also be able to obtain an expert medical opinion to serve as the veteran's nexus letter, connecting their condition to service or even arguing that their condition is worse than what the DBQ or C&P exam had stated. This is definitely valuable if the veteran doesn't treat at VA medical centers as well. Now, piggybacking off of what I had just stated regarding DBQs, veterans may also want to fill out or have their own treating physicians fill out a disability benefits questionnaire, which is a DBQ. These forms allow the veteran or their healthcare provider to answer questions about aspects of their disability, including the symptoms, severity, potential cause, and relation to other disabilities that the veteran may have. Oftentimes, lay statements as well from friends, family, or coworkers who can paint a fuller picture of the veteran's PTSD are also really helpful. Sometimes you may feel like you're underreporting your symptoms, and your symptoms may be affecting others around you in ways that you may not really understand. So getting lay statements from friends, family, or anybody who's really close to you and may have a firsthand encounter as to how you deal with your PTSD or the severity of your symptoms may also help paint a really clear disability picture for VA.
So the last mistake we'll go over is not knowing your appeal options. Veterans have the right to appeal unfavorable decisions from the VA. In other words, if your PTSD claim is denied or you receive a disability rating that is lower than you deserve, you can disagree with VA's decision and continue to seek service connection or an increased rating. Under the new VA appeal system, veterans can choose from 3 different review options, and those options are the higher level review lane, the supplemental claim lane, and a notice of disagreement to the board, which that lane has 3 subsequent lanes to it: the direct lane, the evidence lane, and the hearing lane. Continuing to pursue a claim through the appeals process allows veterans to preserve their effective date and could entitle them to a larger sum of retroactive benefits down the road. Mental health claims can be difficult to navigate, which is why many veterans benefit from the assistance of an accredited attorney or claims agent. Our team has decades of experience successfully fighting for our clients' rightfully earned benefits. If you think you'd like to file a claim for PTSD or have had trouble in the past, reach out to see if our office might be able to help you. Thank you for watching today's episode of CCK Live. Don't forget to subscribe to our channel and follow us on social media for more veterans law and VA content.